tí ń kájọ. Ìbéèrè dópin ilé ayé tá a wá yìí o. Ohun kan ṣoṣo ní àwa tá ò rí. Àlàáfíà nìkan ló lè tẹ́ wa lọ́rùn. Ẹni bá fẹ́ kọ́ bọ́. Mo ti sọ̀rọ̀ tí mo ní sọ. Ìgbẹ́kẹ̀lé ènìyàn asán lórí asán ni. Ẹ fi ọ̀bọ̀ ṣe tí ó tọ́. Ohun rere tí à ń ṣe ló lè mú ayé tòrò. Rántí ọlọ́jọ́ tí ń kájọ. Kí ni ohun tí à ń wá tí à ń fi yá jára wa? Tábà wo ló tún tá sí wo lọ́wọ́ sí? Àlàáfíà nìkan ló lè tẹ́ wa lọ́rùn. Ẹni bá fẹ́ kọ́ bọ́. Mo ti sọ̀rọ̀ tí mo ní sọ.
Hi everyone, good afternoon. My name is Gbeminiyi Obadan. I'm a lawyer, a corporate lawyer, and I'm so glad to be here with everyone today. I really hope you guys can hear me. If you can hear me, say hello in the chat section, so I can just know before I start. Can you hear me? I want to be sure about that before I start. Okay. Okay, yeah, they can hear me. Okay, thank you. Okay, yeah, so let's start. Today we're talking about creatives and the law. I'm aware that I'm speaking to a bunch of creatives. So let's start. I'm currently sharing my screen, and I hope you can all see my screen. Okay, so let's start. Who's a creative? Simple definition is a creative is anybody that creates. So whether you're creating something physical or you're creating something that is not physical, if you create, you're a creative. Another definition I have here is a creative is someone that has the ability to invent and develop original ideas, especially in the arts. We're going to be dealing today with the creative industry, the creative arts industry, entertainment and media, most especially. So if you're a person that has the ability to invent and develop original ideas, you're a creative. And my own definition, it's not the dictionary, but this is just what I think. I think a person who expresses themselves through their creativity is a creative. Some Nigerian creatives that you may know, we have Obadan, R.I.P. to Imole, we have Kiki, we have Mr. Macaroni, we have Tauma, we have T.J. Omori, we have Toyin Lawani. These people on the screen are all creative. According to our definition, I said a creative is someone that creates. So they create different forms of art and express themselves creatively. Toyin Lawani, fashion, Mr. Macaroni, skits or comedy. Kiki, she has YouTube shows, she has skits, she has, all kinds of things. Mobad was a musical creative. Talma also does skits, comedy. T.J. Mori does audiovisual content. He's a video director. Now, because we're talking about creatives and the law, what's the first thing that comes to your mind when you hear law or lawyer? I'm going to give you maybe 30 seconds to quickly type that in the chat section. Let me have a feel of what people think. So when you hear law or lawyer or the law, as we say in Nigeria, what's the first thing that comes to your mind? Are there any chat? Do we have anyone giving any opinion? Okay, so I'm just gonna wait for your definitions or what comes to your mind when you hear law or lawyer or the law. Okay, so Claire Okolus's court. Interesting. Any other person? Bissell Dowd says justice. I like this. Fair enough. Fair enough. I'm glad you have some faith in the judicial system. Any other person? Case. Amina and Ezi Sabi says case. For your case, you interested, interested. Um, Voice Prince says rules and regulations that govern a particular field. I love all this. Everyone has spoken well and everyone is correct in their different way. The thing is that, like the person that said case, a lot of Nigerians, okay, let me take one more. Brother Shaggy. I like to show said Brother Shaggy. Like the person that said case, a lot of Nigerians erroneously think that anything that has to do with the law or lawyers is trouble. So people think you only get a lawyer or you only get the law involved when there's trouble or when there's some kind of contention. But the truth is that the law is there to even do more of protection than defense. So the law, first of all, can be used as a shield. I have here, contrary to popular opinion, the law can be used to prevent trouble. So it's better for you to, it's better for you to be preventive than for you to be defensive. Unfortunately, many of us do not know that there is a side of the law that seeks to protect. And as a creative, there are laws in place to protect you. But if you do not know about these laws, they can't work for you. As they say, very popular, even in Nollywood movies, you hear ignorance is not an excuse in the court of law. The law that seeks to protect creatives is broadly called intellectual property law. I would be saying IP law for short. So when you're a creative, the umbrella of the law that protects you is called IP law. Next slide. Then go to my next slide. Here. So IP law, as I like to call it. When you think of IP means intellectual property. Let me break that down. Intellect and property. So it basically means property that comes from your intellect or property that is owned by your intellect. We have physical property. A physical property is my phone. I'm holding my phone, for instance. I have this earbud charger. I have my pair of glasses. This is physical property. You can see this. You can hold this. If someone steals this from me, I wouldn't have it anymore, right? On the other hand, if someone steals your intellectual property, you still have it in some form because it's from your intellect, it's from your mind. So I'm going to kind of try to define intellectual property. You have physical property. I've tried to explain that physical property are things that can be seen and felt. They are tangible objects, cars, bags, shoes, physical property. Intellectual property is a bit more dicey. It's property owned by you, produced by your intellect. Property owned by you, produced by your intellect. Now, just to explain a bit further, intellectual property has to be something that has been packaged into a service and can be consumed as a service or an experience, like a song. If I have an idea for a song, that idea is not my IP. It's not my intellectual property because it's in my head. It's not yet been packaged into a product or a service that can be experienced or used. If I have an idea for a movie, that idea cannot be stolen. The law cannot protect that idea because everyone has ideas. Everyone can get an idea for the same movie. If I have an idea for a movie, the movie in my head cannot be stolen. But if I have written down the idea into a script, that script can be stolen. If I've written a poem or a novel, a book, that, because I've now packaged it into a service that can be experienced or can be consumed or enjoyed, it can be stolen. So even though, for instance, a work of art, an artist can get an idea for a painting. If it remains in his or her head, it's still an idea. But the moment he expresses it, on a piece of canvas, even though you cannot touch the colors, you cannot feel the colors, but because it's been expressed on canvas, it now becomes property. And the property there is the product or the fruit of his work. IP law does not protect the idea, but it protects the expression of the idea. The idea has to be processed or expressed in a way that it can be consumed. An idea for a song, for a painting, for a movie, for a skit can be protected. The way you decide to shoot a video, your style of photography, it's in your head. But the moment you express that style on the subject, it now becomes your IP. I hope you're following me. If you follow me, please leave comments in the chat section. Before we go further, let's look at two um Nigerian artists or Nigerian creators that kind of suffered from not protecting their IP. I like to get practical. Many of you know Kiss Daniel. He used to be called Kiss Daniel. But do you know that he had to change his name to Kiss Daniel because when he was still upcoming, right? He went by Kiss Daniel. He was signed to a record label. I'm not going to mention the name of the record label. And the record label trademarked the name Kiss Daniel. And the trademark was owned by the record label. Now, due to one or two things that I do not know, there were some issues with Kiss Daniel, the artist, who had gone by that name, who was popular by that name, who had produced, who had released songs, gone for shows, gotten paid by that name. There were some issues with Kiss Daniel, the artist, and the record label. The record label went on to tell Kiss Daniel that the trademark for the name belonged to them. So he couldn't continue to go by Kiss Daniel. And the record label was not wrong. A lot of us try to get emotional about things about the law. The record label, when they found him or discovered him or, did all of the things that we got to know that made him Kiss Daniel, they registered the trademark and it belonged to them. So they had every right to say, you know what, we don't want you to continue using our property because the name had been registered by them and belonged to them. So he had to change his name from Kiss Daniel to Kiss Daniel. Another person we know is Buju. Buju came on the scene and we all knew him as Buju. And suddenly he announced that he had to change his name to Benson, spelled BNXN, right? What had happened was that there's another popular Jamaican artist that goes by the name Buju. And that artist had gone ahead to trademark the name Buju. So in order to, avoid any future problems or wahala, as we like to say, it only made sense for Buju to stop going by that name because the truth is that that artist could decide to sue Buju or come at Buju for, infringing on his trademark. So these are two Nigerian creatives that could have or kind of avoided trouble because of intellectual property. Now, three branches of IP law. We have copyright, we have trademarks, we have patents. Because we're dealing with creatives, the two areas that mostly concern you are copyrights and trademarks. Copyrights, I have here, copyright protects audio, visual, recordings, and literary works. So think of anything that has to do with your audio, your visuals, your artistic works, your recordings, your literary works, from your books to your videos to your music to poems to anything that covers visual, audiovisual, artistic recordings, literary works.
gbogbo tó ń ṣe ìfẹ́ra lámúnú rẹ̀ rántí ọlọ́jọ́ tí kájọ. Ìbẹ̀rẹ̀ dópin ilé ayé tá a wá yìí o, òun kò ṣoṣo ní àwa tá ò rí.
Yeah. Sorry about the break in transmission. My internet went off for a bit, but I'm back now. I just want to be sure that I'm still live on Zoom. And can you see my screen? Is my screen showing? From my end, I can see two different screens. So I'm trying to avoid that. Share screen. Okay, yeah, I think I'm back now. Yeah, sorry for the break in transmission once again. We have copyright, we have trademarks, and we have patents. Because I'm dealing with creatives, I'm going to deal mostly with copyrights and trademarks because those are the two areas of law that affect creatives. Copyright protects your audio. Producer, is there any issue with my internet? Okay, thank you. Thank you. Copyright protects your audio, your visual, your artistic recordings, and your literary work. So think of anything that was authored or that originates from you, copyright seeks to protect that. And copyright is vested on the original creator or author of the work, except their agreements to state that. We'll get into that later. Now, trademarks cover your brand name, your logo, your slogan, your colors. Think of Just Do It. When you hear Just Do It, you think of Nike. That is a registered trademark of Nike. The check sign or the swoosh, as it's called, the swoosh is a registered trademark. It's not a literal work or visual work. It's a design and it's trademarked to Nike. The slogan Just Do It is trademarked to Nike. The brand name Nike is trademarked to the company Nike. And here I have these laws protect the moral right, that is the honor and reputation of the work and its author, and the economic rights, that is the right to earn and profit from the work. So this law seeks to protect just your honor and your reputation as the author, originator of the work, and it also seeks to protect your economic rights, meaning that you can profit from your work and you can earn from your work, and nobody else has the right to earn unjustly from your work if you haven't permitted them to do so. The law would not allow another person to benefit from another man's sweat. That is very correct. The next slide. Trying to go here. So here we have copyright versus trademarks. Copyright is automatically bestowed by law to the author of the work, e.g., the creator of the skit, the singer/writer of the song. For songs, I want to be very clear. A song can have a writer and a performer. So for some songs, you would see performed by XYZ, written by XYZ. In that instance, it just means that the performer of the song is not a writer of the song. So depending on whatever agreement that those parties have, they can decide to share the rights to the song. They can decide, you know what, I would get credits for writing and you would get credits for performing. Or they can decide that, you know what, because you wrote the song, you own the copyright to the song. I just get performing rights to the song. Depends on the agreement. The photographer, in the case of a picture. So, Kelechi Amadiobi, T.Y. Bello, T.G. Omori, and another person that does audiovisual work. The director or producer of a movie. In the case of a movie, most times it depends on, you know, who is the executive producer of the movie and who commissions the movie to be made. I have here that in instances of joint collaboration of a work, parties can agree that the copyright of the work be shared amongst them. This agreement must be in writing. I'm going to get into that later on. But note that whenever it comes to your rights in law, the law favors whatever is written down. Because the thing about oral testimony or things that are said is stories can quickly change, and you cannot easily verify who said that and who said what. But once it's written down, the law favors that. In the case of a work made for another person, for example, if you're a videographer and let's say Davido hires you to come and shoot a video for him, in that case, because Davido hired your expertise, Davido, the law assumes that Davido owns the copyright to the work because he hired you to do it. Now you can decide as a creative with Davido that, you know what, I also want to be able to have some rights to this. You can give me rights as a director and you take rights as a performer in the video. You can always negotiate this, but what is assumed or what comes naturally is that whoever hired someone to carry out a task or perform it, if I invited a because I was the one that invited a photographer to come to my house to do a shoot of me, I own the copyright to the work, even though the photographer shot it. If we agree that, or maybe you can give permission for that. Now, for trademarks, it is important to register your trademark. For copyrights, you may register it, but not registering doesn't invalidate your right. But for trademarks are popularly can be assumed. For instance, if someone says something popularly or someone makes something more popular, you can assume that they own the rights to that, register it. It's important that you register this. It gives more validity. For instance, if you're an upcoming artist and you have a stage name, it's safer for you to register that stage name as for yourself, so that nobody else can use it tomorrow and claim that, oh, they came on the scene before you or they came on the block before you. If you have created a logo for a brand, it makes sense. It's the judicious thing for you to register that trademark so that you can have full right. And if anything happens, you can go to the court and say, you know what, on XYZ day, I registered this trademark with the Trademarks Commission. For instance, an example of something that can be trademarked, I've already mentioned, like you are doing well. Everyone knows that Mr. Macaroni says you're doing well in that tone that he says it. I don't know if it's trademarked, but he can decide to trademark that because it's now become profit of, that persona in the skits that he makes. This is an example. I'm going to give us a little quiz. I'm going to give us 1 minute, oh no, 30 seconds. This is Davido's timeless album art. What area of law would protect this album art? Please type in the comment section. I'm just going to give us 30 seconds and take about 3 to 4 answers. So based off all I've said, for instance, this piece of work, Davido's timeless album art, what area of law would protect this particular piece of work? It's a picture or it's a design. I don't know. Just gonna wait a bit more. Do we have any comments coming in? Or should I move on? Okay, copyright. I love that everyone is getting that. And it means that I'm probably explaining well and you're following well. So everyone please clap for yourself. So yes, because it's a picture or it's a design. Sorry, I don't think I heard you. Did you say copyright? So if you said copyright, you're wrong. If you said trademark, you're correct. King Suicide says trademark. Trademark is wrong. Trademark is wrong. Copyright is correct because this is a picture. I'd said earlier, okay, Samson says trademark, Joseph really says copyright. Copyright is correct. If you said, I think I mixed up my words earlier, pardon me. If you said trademark, you're wrong. If you said copyright, you're correct because this is a picture or it's a work of art. I had mentioned earlier that audio, visual works, audiovisual, photographs, literal piece of works are protected by copyright. So because this is a picture, it's created by someone as an album art, is protected by copyright. I understand how we can think that trademark comes into place here, but trademark is mostly used to show exclusivity to a particular thing. For instance, I mentioned the Nike trademark. If you see the Apple logo, for instance, that is trademark. That would not be copyrighted. It will be trademark because it's a logo that shows that it belongs to a particular brand. I made mention of the word "You Are Doing Well" by Mr. Macaroni. That is also something that can be trademarked. It can be copyrighted, it can be trademarked. This is a visual work that you can see. On the other side of my screen, I have a couple of songs from Davido's Timeless album. I wanted to use this as an example to show how rights can be given in a musical work. So here you have the name of the song, Over Them. We all know the song. So you have writer and you have producer. If you can see my screen, you have writer, you have producer. The writer of the song, you have Davido Adeleke, that's Davido. You have Young Alpha as also a writer, and they have Young Alpha as a producer. So here you can see that everyone has rights. It doesn't mean that, oh, this person owns the song exclusively, or we all collaborated on this. So they would have all agreed contractually to have XYZ rights to the song. Or I'll give you rights as a writer on the song. I'll give you rights as a producer of the song. Here you have Feel. Feel was written by Marcel Akunwata, written by Adeleke David himself, and produced by Blaze Bates. So when you have issues of producers saying, oh, I'm the owner of the song, oh, the artist says, oh, I'm the one that owns the song, you can just thought that there was no lawyer involved in the process. Even if there was no lawyer involved, you can decide amongst yourselves to write down something. So, okay, because you're working on the song with me, I'm the one that wrote the song. I would have rights as a writer. You would have rights as a producer. We can split profits whichever way we agree. You have the song In the Garden also featuring Moravi. Davido has rights has writer rights. Moravi Shoronke has writer rights. Abiodun Rore also has writer rights, and they have Blaze Beats producer. You have the popular song Unavailable. Musa Keys has writer credited to him. David Adeleke has writer credited to him. And you have Tobichukwu Okolie, who is also known as Peruzzi, as a writer on the song. And then you have Magic Stick as a producer on the song. I hope I've tried to explain as well as I can. I'm going to the next slide now. Yeah, another case study. I think sometime last year, news went round about Mr. Fonny, aka Sabinos, suing Peak. Okay, I wrote it here. Mr. Fonny, aka Sabinos, sued the makers of Peak Milk and Gala for 1 billion naira and 500 million naira, respectively, for using the phrase something huge, which he made popular and had trademarked, and for using his likeness in an image, likeness/image in an advert without taking his consent. So what had happened was that we all know that something huge became popular because of Sabinos, and apparently smart of him, he had gone ahead to trademark it because it's a slogan that he made popular. Now, Peak Milk, or whoever was in charge of the digital marketing of Peak Milk, decided to use the phrase something huge is coming in an advert. And Sabino said, no, you can't do that. I was the one that made this phrase popular. It wasn't even a matter of saying something huge, as we know, it was something huge as he had made popular. and he said he was going to sue, or he did. There's some papers actually on the internet about him suing for 1 billion naira. I feel, this is my opinion, I may be wrong. I feel that they may have settled, amicably outside of court. What happens in cases like this is that if you're going to use something that someone had made popular, you can seek the person's consent to use it. You as a creator also, if someone has used something that you made popular, or for instance, in this other picture, they use his likeness. Anyone that sees this can tell that this is Mr. Funny or Sabinus. They use his likeness. So if you're creative, you're a photographer, and you take someone's picture and then you use that picture in an advert or to make profits or to do anything that they did not consent you to do, they can take legal action against you. You also, as a creative, if you come up with something and someone uses it unjustly without taking your consent, you can take legal action against them. If you, as a photographer, you take maybe like a picture of nature or a model, you are the one in this case that's commissioning this shoot, and some big brand sees the picture and decides to use it for whatever use, you can take them to court, or you can reach out to them and ask them to pull it down. If you, as a model, you have a picture on the internet, someone else sees that picture of you as a model, professional model, and someone uses it for an advert or for whatever without your consent, you can very well take legal action against them because you are the owner, you own the rights to that. So in this case, Sabinos had said it was going to sue Picnic for 1 billion naira and sue Gala for 500 million naira. Was well within his rights because, as I said, he had trademarked the name something huge. Next slide. Now that we're done with trademarks and copyrights, this is an area that I feel a lot of creatives because of excitement and because of I don't know, whatever reason, you fail to document very good, and it can be very bad. Contracts can and will protect you, and if you're ignorant of your rights, a contract, you can actually yeah, thank you very much. I'm sorry again for the internet. It keeps going on and off. But we're almost done. So I was saying that contracts can be used to protect you, and contracts can also be used to literally ruin your life as a creative. Why do I say this? You can sign something that you are not aware of. I've experienced cases of people literally signing away their entire life's work. For instance, I want to ask, is popularly as we popularly say in Nigeria, oh, this record label finds this artist on the streets, and they bring him into the record label, and things start happening. He starts releasing songs out of excitement. The record label will probably give him a contract to sign. This young artist that doesn't know what's going on will just sign and say, oh, that I'm being signed to this record label, I'm being signed to 10 years, belongs to them. There could be clauses that say that anything you do, anything you sing, if you sing A, B, C, D, it belongs to them, and you sign it. You can be signed as a photographer to a brand, and there could be clauses that say that on anything you shoot belongs to them. You can be signed as, a DJ, a model, a videographer, and you literally sign away, your life without knowing. So I have a general rule of thumb to follow for creatives is that you must document everything. If someone says, oh, I want to sign you to my label, or I want to bring you on a project, I want you to come and do something for me as you're creative, I like your work, if any popular person or any popular agency approaches you and tells you that they like your work, before you get excited, before you get happy, write down everything that they are saying. If they say they're going to pay you $20 billion for your work, write it down. Mr. This said they're going to pay me XYZ for this. And ask them, what work do you want me to do? It makes sense and it protects you if you highlight the scope of work. Oh, you want me to shoot 20 videos for you. Don't let them say, oh, just come and be shooting videos for us. As things go, we'll see how things go. Don't take that. It will end in severe tears, I beg you. What do you want me to do? Okay, you want me to shoot videos when you go on tour. How many hours of videos do you want? How many minutes of videos? Do you want me to edit the videos or will I give somebody else to edit? Do you want me to include special effects? Do you want me to go on tour with you? Would you cover my transportation when I'm on tour, my feeding on tour? All of that, write it down and make them sign. Even if you do not have the funds to get a proper lawyer, if you just simply write what they say down, ask them, oh, this is what we agreed. Because you know the thing about agreements is that you just talk and you're excited. I'm going on tour with XYZ big name. They're taking me around Nigeria. I'm going to be the videographer. I'm going to be the photographer. And then you take pictures, you take videos, and then you come back on Instagram and say, oh, Instagram blog, come and help me. They've stolen my work. Nobody stole your work because you signed your work over or because you were not clear in the beginning about what you wanted from them and they took advantage of you. Sometimes out of excitement, creators forget or neglect this step. You must also seek legal help to read through whatever contract you're asked to sign, no matter how much money is promised to you. This is very important. If you cannot afford legal help, I always jokingly say, make friends with a lawyer. Because I mean, my friends, they would usually just, oh, baby, can you help me look through this? And if I'm in a good mood, I wouldn't charge. So if you cannot afford, make friends with a lawyer or farms a lawyer so that they can just help you go through certain things and you don't get into trouble. Remember that relationships can quickly go sour, so you must always look out for yourself. I do not want to think that Kiss Daniel would have imagined that the people that brought him into the industry, quote and unquote, and he released so many songs for, and they made so much money together, will later come and say, you cannot use this name, the name that he owns that belongs to him, quote and unquote, even though legally it doesn't belong to him. I do not think that he would have assumed that, someday will happen and he would have had to leave the record label. The law favors written agreements over oral agreements. Oral testimony can change and quickly become unreliable. I say this because, if myself and whoever is online makes a contract, tomorrow I can say, oh, I didn't say that. You can say, no, you said that. Oh, I didn't say that. Oh, then it becomes a whole thing. But if you write it down and I ask you, look through this, sign your signature and put a date to it, that holds more water than, no, you said you give me 10 billion naira. No, I said I want to give you 10 kobo. Oh, no, no, no. I said you do 20 skits for me. Oh, no, you said I only do 2 skits. That becomes a whole thing. And then it becomes Insta blog and Tunde, no, come and help me. They say they've taken my work and all of that. We want to avoid tears by all means. Now, some simple contracts that you should have as a creative: a service level agreement. This agreement is very basic. As a creative, you are a creative yourself, and you also sometimes will offer services to people. You should document this. And SLA would help you highlight everything you're doing. Okay, what did they say I should do? How many, for instance, if it's a photo shoot, how many dresses are you changing into? How many hours of my time do you need? How much did you promise to pay me? How much are you going to put as down payment? Everything is written down. Oh, how long are we going to work together for? Oh, 2 weeks, 1 week, 1 day. All of this is very important. How do we split the profits from this business agreement? Oh, 50-40, 50-60, 60-100, all of that. It's in a service level agreement. I added this, a podcast guest agreement. If you're a creative, you have a podcast, you want to have an agreement for your guests, because there have been instances where guests will say, you can't use my picture or my video to promote your podcast. That sounds funny, but best believe that there are instances where you could invite a guest to your show and the guest can turn back and say, no, 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 you can't release that. You can't release that. I will sue you if you release that. After all, it's my likeness that's in the video. You can't release the podcast. And you say, But you said that you give me the exclusive news. You said that you give me. No, 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 you can't release that. I'm sorry. And then you've lost your footage. You've called people to come and shoot you. You've wasted your time and your money. Employment or independent contractor agreement. I would explain this. An employment agreement is, let's say, as a creative, you're building a team, for instance, and you want permanent people on your staff. You want maybe a script writer, you want a movie director, you want a makeup artist, you want a light boy, you want all of these people on your permanent staff, you want them working for you exclusively. You would give them an employment contract. But if, for instance, you want them to only work per time or per project, that means you don't own their time exclusively. It's only whenever you have work for them that you would call them. You give them a freelance agreement or an independent contractor agreement. If you have a makeup artist and you don't always use her services, you only want her to come sometimes when you have shoots, you give her the agreement. In the agreement, you state everything there. Oh, you're going to do makeup for 5 models. You're going to do makeup with lashes and change the lipstick 3 times. You want to be as clear and as explicit as possible in your agreements so that you can avoid stories that touch. A non-disclosure agreement. This is very important. Sometimes it's also called a confidentiality agreement. There was something I saw on the internet the other day with Teddy A, the former BB Niger contestant. Apparently, from what he said, she had this idea. No, I told you that the law doesn't protect ideas, but the law protects the fruit of your idea. He had this idea for, I think, a football show, and he shared it with someone in the industry. Like, oh, you know what? I have this idea. Let's rub minds. Let's connect on this. A couple of, I think, weeks, months down the line, he claims that this person that he shared the idea with went to get sponsors and basically executed his idea. Now, what can he do in that instant? Nothing, literally, because he's the one claiming that he shared the idea with somebody. Nobody else can verify that fact. The other person probably say, "No, we never met. I don't know what you're talking about." But if 38 had taken a non-disclosure agreement to this person and said, "You know what? I want to share this idea with you, but before I talk about what I have in mind, sign this agreement saying that I'm the disclosing party. You would not share or execute, or this thing we're saying stays between us." That way, if this person goes ahead to execute the idea, he can come and say, "Oh, but we talked about," because the agreement usually have highlights of what was discussed. "Oh, I came to you with an idea for a football show. I came to you with an idea for a basketball show, for a makeup show, for a fashion show on XYZ date." That is evidence enough. And that person has the right not to disclose whatever was discussed. And the person goes ahead to disclose it. You can go to court, you can get a lawyer, you can basically take legal action against the person, right? Because it's evidence. As somebody once said, you go explain, tire, evidence, no day. But in this case, you have evidence. A partnership agreement. Partnership agreements are always good for when people are collaborating on a project. You have maybe a makeup artist and a photographer coming together to do work. If they're coming together as partners, it will be good for them to have a partnership agreement stating that we're coming together to do this work together. We will split profits equally. I would bring XYZ amount of money to start with. You will bring XYZ amount of money. I will do. It's always good to write these things down. Last but not the least is sponsorship agreement. This is always very good for if you're growing a brand and you begin to get sponsors for the brand. You see a lot of news out there. Oh, XYZ just got signed to this brand. This brand just sponsored this person's show. This brand just sponsored this person. All of this is good. It's good for the Instagram optics, but it's important to always document the agreement. Oh, this brand says they're going to sponsor 4 videos that you make. So you ask them, okay, how do you want me to hold the product in the skit? How do you want me to show your product? Does this mean that I cannot touch any other product that is similar to yours? All of these things is clear in the agreement stated. In conclusion, remember that the law can act first as a shield to you as a creative to protect you from trouble and can also act as a sword if your rights have been trampled upon. The law can act yes. Yes. So again, the forces are really against me with the internet today. Yeah, but the good thing I'm already concluding, as I said, the law can act as a shield and as a sword. But if the law cannot do anything for you if you're ignorant of your rights or if you refuse to take the right steps. I really hope you enjoyed my short session. I really hope you learned. And I'll now open the floor for questions. So please put your questions in the chat box and I'll read them out and answer. I think we have 15 minutes for that. Okay, so I'm going to read the question. How about situations when you use the person's video on a social media post without content, but credit the owner by acknowledging ownership, and the content is now commercialized? Is this still an infringement or the acknowledgement is sufficient? Okay. Uh okay. Okay, let me read again. I can't see okay, let me read it again. And the content is not commercialized, is this still an infringement or the acknowledgement is sufficient? Now, you've said that in the case where you use the person's video on a post without their consent, but you credit the owner. First of all, it's always best to get consent. Acknowledging the person is just saying, you know what, this doesn't belong to me. In the case that the video goes viral, if the owner says, I don't like that you went viral with my own post, they have a right to ask you to pull down the video. And I know even with Instagram, they can actually report you to Instagram and say, you know what, I don't want them posting my video. So even though you didn't steal the content and you're not profiting off it, they still have the right to say, please take my video down, pull my content down. I don't want you posting my video. It's a good thing, it's a moral thing that you acknowledge, but I wouldn't say suffices for consent. No, it doesn't. Next question, Jude Uzonwane. My photo was used in an advert without my consent. How do I challenge that? You challenge that by going through your lawyer. Your lawyer can write a letter of demand asking them to pull down the content. Your lawyer can decide to go to court and file a suit against them. You do that through your lawyer, or you can even reach out to them on your own. But it's always best to go through a lawyer because a lawyer, you know what, a lawyer carries more force of law. I've had a case where someone came to me with that and he had shot a video for a particular product and somebody used it. So I wrote, and he had gone to them on Facebook saying, oh, pull down my video. I shot the video. The person ignored. But the moment I wrote a letter saying, this is my client, this is the evidence that they own this video, you're infringing on their copyright, Person took the video down immediately. Is it possible to have a copyright over an artwork submitted in a competition? Yes, you can. But what I would advise is that when you do that kind of work, make it clear because it's a competition. Some people can get funny, some people can get shady. Sometimes the sponsor of the competition may want to, take advantage. But if you make it clear to them that I'm submitting this work, it's my work. The truth is that even by law, you own the work because you were the one that did the work. Never mind that you submitted the work for a competition. They did not commission you to do the work. It was a competition. You did the work yourself. So you actually own the copyright. But if you can, always make it clear, put it in writing that I'm submitting this work, but I still reserve the rights to this piece of work. It's simple. Ivy says, please can you register like 4 of your ventures under one name? Like if you offer sales of products and creatives and then animation creation. I'm not quite sure I understand this question. Can you register like 4 of your ventures under one name? If you're talking about corporate incorporation, if your company offers 4 different activities, yes, you can register 4 things under one name if that's what you mean. But I'm not quite sure I understand what you mean. But yes, a company can decide they want to go into animation, they want to also sell products, and they can do all of that. It's allowed within the law. Stephen Iwaha says, if a copyright and trademark is registered in the UK, can it be registered by a different person in Nigeria? No, it cannot. Copyrights, trademarks are jurisdiction specific. What can happen though is that someone that has registered something. I have a client that had, done some work for an app and had used a particular logo for the app and put it on App Store. And some company in the US came to her and said, you know what, this name you said is registered in the US, and we've also tried to register it in some African countries. So would ask you to pull it down. I advised her in that case to pull it down because they had gone ahead to register the name in other African countries that were close to Nigeria. So it can be assumed that she got the idea for that name by seeing it on the internet. It was very dicey, but she has to take it down. So it's always important. Trademarks and copyrights are actually country specific. Although for copyright, because it's bestowed on the author of the work, it's not country specific. But for trademarks, it's usually country specific. But if you can prove that you have started using this trademark before this person came on board, or that you made it popular, if you can prove your timeline, you're good to go. But it's always advisable to register trademarks in different jurisdictions where you know that you will be using the trademarks. If I trademark my video production brand, do I need to copyright? No, you don't need to copyright every video or graphic content you do. As I said, you don't have to register your copyright. You don't have to register that. Copyrights are inherent. They're bestowed originally on the owner or the author of it. So if your video production brand, maybe the brand name or the logo is trademarks, you're good to go. No one else should profit off that brand name. But whatever product or work comes out of that video production brand, you don't have to copyright it. The copyright already is bestowed on you because you are the original author or creator of that work. If you have a video showing that there was a signed agreement and the paper was torn by someone, is the video still valid? This is interesting. So if you have a video showing that there was a signed agreement and the paper was torn by someone, I have questions. Who tore the video? Who tore the paper? Why did it tear? But if you have evidence showing that somebody signed an agreement, evidence is evidence. If evidence is evidence, the video or the agreement is still valid, even if someone goes ahead to tear it, it's still valid. If that video can show that yes, they did sign and it's their signature that was on it, evidence is evidence. Can an employee claim over a creative work he or she did while working for the employer? No, you cannot. As I said earlier, whatever work you do, even though it belongs to you, if you were commissioned by someone to do that work, for instance, if you're a graphic designer and don't know what agency, MasterCard asks you to come and work for them full time, and then while working for MasterCard, you create a very notable design, that belongs to MasterCard because you were in their employ when you created it, except you have agreed beforehand with MasterCard that you would retain rights over whatever you created. How do you register your songs to get royalties when Nigerian copyright bodies are always having legal disputes and national disputes? This is the whole I want to say, can you email me? But for royalties we have bodies like Coston and I can't recall the other body that do handle royalties. But I want to assume that certain record labels that have proper structure also cover royalties for their 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 creatives. So if you're under a record label that has proper structure, or if you have licensed your song to be used for any project, you do have royalties. You should earn royalties. But is your song on a platform? Is it on Spotify? Is it on YouTube Music or Apple Music? Have you licensed it to any companies to use? These are questions that I'll need to ask to get more clarity. Um, my photo was used in a thing. Oh, I think I already answered this. My photo was used in an advert without my consent. Jude Uzonwane says my photo was used in an advert without my consent. How do I challenge that? I think I already answered this. Um, is Voice Princess, is SL agreement the same as scope of work? Scope of work would ordinarily fall under an SLA. So under an SLA, you would have scope of work, but scope of work can be used in place of SLA, but SLA can be more robust depending on the nature of the agreement. Candace Art says, insightful, educative. Thank you very much. Prime Studio says, we don't agree for the network. I also would not agree for the network. I'm very stubborn also. Thank you very much. I think I have okay. Francis Mora says, what if you have a work already out for some years and someone else uses the name of the character and likeness without telling you what to do? You would have to prove that you do own the work and that the person indeed, you know, intentionally or maliciously used a character and likeness. That's why if you watch movies sometimes you first see a disclaimer, oh, please note that the character and likeness used in this video is not to spite anyone. There's usually something like that whenever you watch videos or music videos or movies. So there's a lot of proving to do to show that the person did use your own character and likeness without telling you. Because as I said, ideas can be given to anyone and everyone. But you have to prove that this person did, maybe you came in contact with the person, maybe the person saw your work somewhere, maybe you have to prove that. Do clients have the right to ask for project files or raw files from video shoots taken during a shoot for a commercial? This is very subjective because I would say the raw for a commercial shoot, who commissioned the commercial shoot? What agreements do they have with you? Have they said beforehand that they're going to take all the raw? Because I understand as a photographer, the raw you feel entitled to your raw photos because I mean it's yours. But it will be good if before you start working, you make it clear. Oh, I want to own the raw shoots. I want to own the raw videos. It's always good to make it clear. If not, you just open the door for dispute. I also they have a right to ask for it, but I would say to prevent such from happening, preempt them by making it clear in an agreement. Is business name registered? No, no. I'm going to read the question out. Is business name registration the same as trademarking? No, it's not. No, it's not. No, it's not. No, it's not times 100. Business name registration is done with the Corporate Affairs Commission. That is simply saying that you now have the legal right to work or legal right to use this name to work, or you're now a person at law that is trading with this name. A trademark protects your brand, protects the name. For instance, I'm going to go ahead and say my name is Gbeminiyi, for instance. If I go and register Gbeminiyi companies, that's fine. It's just saying that Gbeminiyi companies is now a person known to law. But someone else can go and decide to trademark Gbeminiyi companies as a trademark and they start using it because they have gone to go and tell the law to give them exclusive use to this name. So trademarks is done with the Trademark Commission. CAC doesn't cover your name.
Àsìkò ayé tá a wà ó dàbí ẹni tẹ ọmọ owó tún sí lọ́ọ̀sì nínú gbogbo tó ń ṣe ìfẹ́ ara la múnú rẹ̀ rántí ọlọ́jọ́ tí kájọ. Ìbẹ̀rẹ̀ dópin ilé ayé tá a wà yìí o òun kò ṣoṣo ní àwa tá ò rí àlàáfíà.
Okay, yes, I was just informed that someone asked, is WhatsApp a written agreement? Yes and no. Yes, because it's written down and it can be used as evidence. But is it a WhatsApp chat? Is it a proper agreement? Is it a proper letter? These are questions I need to ask. But if it's a WhatsApp chat, it can be used as evidence of, written, like two of you came into an agreement and it was written. But I wouldn't call it a binding contract. I wouldn't call it a written contract, but it is evidence that yes, something did go on between these two people and they agreed to certain terms and it was written down. The issue with the WhatsApp chat is that, as I said, when you have a written agreement, so both parties will sign. But with the WhatsApp chat, did they sign it to validate that it was them? Can someone claim that no, you photoshopped when the days of Photoshop, someone can say, oh, you Photoshop that. I didn't say that truly. So it can be dicey, but it can be used to prove that, yes, we did have a discussion on this. It can be used as evidence, but I would advise you get a proper agreement done and not rely on WhatsApp chats. Yeah. Thank you very much, everyone. I hope you learned, and I'm getting the signal that time up. I would share my email address. I can share the slides. I can speak with the facilitator and share the slides. The slides are my they're copyrighted to me. It's my intellectual property, but I would gladly share. I would also share my email address. It's Gbeminiyi Obadan, Gbeminiyi Obadan @gmail.com. Gbeminiyi Obadan @gmail.com. You can email me if you have any questions. I'll gladly answer. Social media, I do not exactly share legal content on there, so I would not be sharing that. Yeah, thank you very much, everyone. It was fun hanging out with you, and I hope you did learn. Please email me if you have any questions or if you have any comments. Thank you very much, Mastercard, for the opportunity. I'm really grateful. Am I good to go?
Alamonore, Roti Yolojo Tikaljo. Ibere dopi ilea ye tawaio. Oun koshosho ni anwa taori. Alafaliko lolete walorun. Eni bafe kobo. Monti soroti moni so. Ibekele eniyo ason lori asoni. Efi yobo shady oto. Onwere ti anshe lole mwaye toro. Ronti yolojo tinkaljo. Kenyon tianwa tianvia jarawa. Taba wolotun tasiwo wolowosi. Alafia liko lolete walorun. Eni bafe kobo. Moti soroti moni.